5 seconds from now. The judiciary has sought to curb this menace of criminalization of politics through several seminal judgments and attendant directions to the government and the Election Commission, primarily based on the aforesaid provisions, specifically orders of the Supreme Court seeking to engender a cleaner polity can be classified into three types. First, decisions that introduce transparency into the electoral process. Second, those that foster greater accountability for holders of public office. Third, judgments that seek to stamp out corruption in public life. The discussion below is not meant to be an exhaustive account. It merely illustrates the trends in Supreme Court jurisprudence relating to the question of decriminalization of politics. In Union of India versus Association for Democratic Reforms 2002-5 SCC 294, herein after ADR, the Supreme Court directed the Election Commission to call for certain information on affidavit of each candidate contesting for parliamentary or state elections. Particularly relevant to the question of criminalization, it mandated that such information includes whether the candidate is convicted, acquitted, discharged of any criminal offense in the past, and if convicted, the quantum of punishment, and whether prior to 6 months of filing of nomination the candidate is accused in any pending case of any offense punishable with imprisonment for 2 years or more, and in which charge is framed or cognizance is taken by a court. The constitutional justification for such a direction was the fundamental rights of electors to know the antecedents of the candidates who are contesting for public office. Such right to know, the court held, is a salient facet and the foundation for the meaningful exercise of the freedom of speech and expression guaranteed to all citizens under Article 19(1)(a) of the Constitution. Again in People's Union for Civil Liberties versus Union of India 2003 to SCC 549, herein after PUCL, the Supreme Court struck down Section 33B of the Representation of People Third Amendment Act 2002, which sought to limit the ambit of operation of the earlier Supreme Court order in the ADR case. Specifically, it provided that only the information that was required to be disclosed under the Amendment Act would have to be furnished by candidates and not pursuant to any other order or direction. This meant in practical terms that the assets and liabilities, educational qualifications, and the cases in which he is acquitted or discharged of criminal offences would not have to be disclosed. Striking this down, the court held that the provision nullified the previous order of the court, infringed the right of electors to know, a constituent of the fundamental right to free speech and expression, and hindered free and fair elections, which is part of the basic structure of the Constitution. It is pursuant to these two orders that criminal antecedents of all candidates in election are matter of public record, allowing voters to make an informed choice. The Supreme Court has taken several steps for institutional reform to sever the connection between crime and politics. In Vineet Narayan versus Union of India 1998 1 SCC 226, a case concerning the inertia of the Central Bureau of Investigation (CBI). Stop. Hello aspirants, please subscribe to my channel to get all the dictations of the latest judgments of High Courts and Supreme Court. Thank you.